We have a guest, and the guest is Professor Jack Mwimali. He is the CEO and the editor of an organization called the Kenya National Council for Law Reporting. The Kenya National Council for Law Reporting. He'll tell us what that is. Professor Mwimali, karibu sana.
Thank you so much.
It's good to have you in the show. This is a situation room. That is the hot seat. Make yourself comfortable.
I hope it will not burn me.
No, it won't. Mm-hmm. It will not. Prof, what is this, the Kenya National Council for Law Reporting?
The Kenya National Council for Law Reporting is actually a statutory body created under the National Council for Law Reporting Act. It's an act of parliament, number 11 of 1994. So we are created by a law, a statute that has been passed by parliament and bestowed with a mandate of publicizing or publishing legal information. So our role or our mandate is just to report on the laws of Kenya. Of course, then the question would be, what are the laws of Kenya? We are a commonwealth country, we are a common law system, and in a common law system, the sources of law are both statutory and case law. So we publish and report on statutes and case law. Mm-hmm. Of course, beside the mandate that has been conferred on us by the National Council for Law Reporting Act, we also have some statutory instrument, other mandates that have been given to the organization through legal notices. So some functions that are played by the Attorney General's office have been given to us to work on behalf of the Attorney General's office. So basically you'll find we publish the laws of Kenya. And I think any person who's gone online and looked at the laws of Kenya, the first place or the first port of call would be Kenya Law, which is our brand name for the National Council for Law Reporting. But we also publish case laws, every decisions of courts that have been rendered by Kenyan courts, especially the courts of record. We are talking about the High Court and the courts of equivalent jurisdiction, the Court of Appeal, and the Supreme Court. Yes.
So whenever somebody wants to go and search, let's say, Constitution of Kenya 2010, or we're talking about any act, this particular act, the Kenya National Council for Law Reporting Act, if I went and searched for that act,
Yes.
one of the searches, the search results, one of the top search results is going to be the act itself, and the website will be kenyalaw.org.
Yes.
That is you.
Yes.
kenyalaw.org.
That's us.
If I went to search what a certain judgment of or a certain ruling of a high court was, let's say we're talking about this issue of whether MCAs should resign before elections or not, this matter has been canvassed in court and there's been an outcome of the court. I search, you have already put it online.
Yes. And in fact, what we are trying to do currently is to be as most updated as possible, so that you'll find even decisions that were rendered, say, 2-3 days ago will already be in our platform. Of course, we are trying to work with other entities who have a similar mandate, like the government printer, who then must gazette those laws or those provisions, especially if it's a law that has been passed by parliament. It must be gazetted to be enforced. So we must work with the government printer, ensure that the official act, the official statute is given out to the public. And that is what we are doing. So we are not just giving information, but we are giving it as up to date as possible. We try and make sure that you are able to access information as at the current time.
What's the scope of the information that you're putting out here to the general public? Because then there's a question of, all right, somebody was, charged with what would be seen as a misdemeanor, for example, and then that case is adjudicated, and then you have something as high as a criminal case. What's the scope that this information is being shared?
Our scope is to publish decisions of what we call courts of record, courts of superior jurisdiction, because those courts' decisions are binding on inferior courts or on subordinate courts, so that any decision of the High Court, Land and Environment, and those court of that jurisdiction.
Labor relations.
Labor, environment and land and labor relations court. All of them must be published because those decisions will be binding on the magistrate courts. So we do publish those ones. But we are even looking beyond just publishing the courts, the decisions of these courts, and to publish the decisions of magistrates, and to also publish decisions of tribunals. Now, these are not decisions of record. They are not precedent setting. So a future court would not cite those decisions as binding upon them, unlike the ones of the High Court, Court of Appeal, and Supreme Court. But that notwithstanding, there is a sense of accountability. Actually, the chair of our council is the Chief Justice, and the Attorney General also sits in the board of the National Council for Law Reporting. And one of the provisions in the Constitution is about accountability. So the thought of our chair is to also use this organization as an accountability mechanism. We will start probably publishing decisions of other entities like tribunals, which we have already started, selective tribunal cases. But in future, we are also looking towards publishing decisions of magistrates, so that if a magistrate makes a decision that is a bit worrisome, there would be of the fear that that profile will be viewed by every other person. And therefore, you will be a bit more cautious on the way you express yourself and you publish these decisions, or you prepare those decisions. Yes.
There's something that you mentioned there that is critical, which is once a bill has gone through Parliament, it goes to the President, it's assented to. You don't publish it until it is gazetted.
Until it's gazetted.
So it has to be gazetted before it gets onto the kenyalaw.org.
Yes.
That means that the Kenya Gazette is the one that is actually now holding your hand, sort of.
Yes, it's an organization, or the government printer, so to say.
The government printer,
is the one that we must work with, because at least what is gazetted by them then becomes law of Kenya. Unless it's gazetted. And that we have a challenge, actually, that is ongoing in court. Decision was rendered that a law is not a law. And that was in relation to county governments. Most of the counties have passed laws. They have it has gone through all the processes, but it has not been gazetted. Now, one of the things that we've been trying to do, as I have indicated, is to ensure that the information that we give out is as up to date as possible. So we get that information because we liaise with the counties and we publish those information. And somebody then goes to court and says, wait a minute, I have not seen a gazette notice under which this law has been published. So that is not a law. And actually, the court agreed with this gentleman who went on that basis, because unless it's gazetted, then it is not
law.
Formally law, although it has gone through all the processes. But there's also one thing about that situation, because at the end of it, the counties are also supposed to have their own county gazettes under the new constitution. Unfortunately, there is no framework for the county gazettes. So all counties must rely on the government printer. And that has been a bit of a challenge. You can imagine all the 47 counties, all the legislations, statutory instruments, those that attach to those legislation must actually go through the same government printer. And one thing that you may note as a bit off at the moment is that there are actually clear provisions on publication. And publication at the moment emphasizes on physical hard copies, not the soft copy. So unless they have released the physical hard copy, then it is not really a published statute or a published document.
How does this, the question then come in my mind is that, how does this then provide a service to Kenyans, the general public? What does it do that, in the absence of which there would be a gap?
As I have pointed out, number one, the Act itself precedes the Constitution. It's a 1994 Act with certain changes in between. But come the 2010 Constitution, and it gives members of the public and every individual the right to information, Article 35 of the Constitution. What is the information that is being required to be provided there? Every information held by the state that is important for exercise of individuals' rights. So anything that can facilitate you to enjoy your rights is public information, which we are proactively required to publish. So constitutionally, that is a mandate that is given to us. And therefore, by us publishing this information, we are letting the public know that there are these documents and this information. Of course, our statutory mandate is about tracking the jurisprudence that is created. So for example, there's a decision in court, and you know, if it's a superior court, those decisions are binding on other courts. Unless you are aware about the existence of this law, the judgment law that is contained in these decisions that the courts have rendered, then you may be acting in error. Sometimes, as lawyers say, you may be in an honest but erroneous belief. An honest but mistaken belief.
Honest but mistaken belief.
You know, the thing that I've been pondering about, what you do is of utmost importance to the citizens of the country.
Yeah.
But beyond people who are in the business of legal matters and legal affairs, who understand and must consume the information that you put out and that you make available, what else do you do to let the general public know about this very same thing? And how do you get the general public to know how they can benefit from all this?
Initially, when we started, I think publication, of course, in 94, but serious dissemination probably in 2004, 2005. When our website was rolled out, if you remember that time, you needed to have subscribed to that database in order to access that information. But it got to a time when we started to engage with partners. And one of the points that came out clearly is, if we do limited premium content provision, then this information will only go to the hands of a few people. Maybe the elites, the lawyers will use them, and therefore it will not be accessible to the public. Right now, we have put it out there as free, open legal information, so that anybody right now wanting to know about what laws are in existence, you go to Kenya Law, you get it. But besides that, we also provide other services, again, by understandings that we have and by other statutory instruments. So, for example, today, if you want to know which cases are in court and at what time, you need a course list. You would have had to go to the government printer or the court to get that course list. We do provide those course lists to the programs of the court in Kenya on a daily basis. If you want to know a gazette notice that has been given, again, you go to the Kenya Gazette. Instead of going to the government printer, getting it from the government printer in the form of the physical Kenya Gazette, you can easily access through the Kenya Law website. Of course, now we are publishing laws of Kenya. And not just the laws of Kenya, we're also publishing updated laws of Kenya, but retaining the original copies. So, for example, if you had a succession case in 2010, it is unlikely that you will find every legal provision that is currently in force is the one that is applicable to your case. And we have even succession case dating back to 1970s. The Succession Act became a law in 81. Now, which law will be applied to you? How do you access that law? Because if you come and take the Succession Act as is today, then that is not the law that is applicable to you. So you know there is that progress, but there is also that contemporary and timeliness of the laws that we supply. So we are not just giving you information as is now. We also tell you that there are other provisions, including now the 2010 Constitution, yes, but there are cases that may have originated or emanated from issues that arose before the 2010 Constitution, which will be the applicable Constitution, is the repealed Constitution.
You know, where I come from, people grow sugarcane. And one of the things that is a problem for most farmers is that they also grow maize for subsistence. And there are wild hogs that share this maize with them, uninvited, of course. And there's a saying among the people who come from where I come from, if only these hogs knew how sweet the cane was, they wouldn't bother us with this maize. Okay? Now, what you're saying is music to my ears, but I suspect I didn't quite ask the question correctly. Let me ask it differently. I understand, I know. For the general public to know, beyond publishing,
Yes.
is there anything else you do? Like, for instance, if you want to know that there's a detergent, those who make it will make sure they advertise on radio. If your radio is on, you're going to hear it until you're tired. Okay? If they are advertising a soft drink, they'll do the same. If they want you to use a certain communication product, they'll do the same. Now, this product, in my mind, is of extreme importance. Is there anything you do along these lines to ensure that the public actually knows about these important things that you do?
Actually, we have been publicizing ourselves. And in fact, in our strategic plan, which is coming to an end, and we are now developing a 2022-2027 strategic plan, one of the important sectors in the organization is the public communications, where we go out and give this information to the people. And I agree with you, in most cases, people know or even interact with us, but they don't know who we are. So we are going out there, and that's why I'm delighted that you've brought me to this show, so that people would understand these things that we see there are created by a particular entity or group of people. Of course, for me, as a worker in that organization, I would not be. I would not like to be bogged down by bureaucracy and politics. But I also want people to know that there is this entity or organization that is giving this information, and therefore we are now going out. We are now moving from just publishing and giving this information to interacting with the people. We are also doing corporate social responsibilities. We want to interact with the people. As we plant the trees with them, they know, oh, there's this entity, there's this organization that is doing this work. And therefore, you get to know us on that basis. Perhaps that's probably one of the shortcomings that we have had in the past, that we have done very good work. If you go to the public entities monitoring structures, they'll tell you Kenya law is one of... we have actually been the best public sector organization for the last, I think, 3-4 years. But
Best in what?
Yes.
Best in what?
Just if you look at all public entity or public sector institutions, in terms of meeting their mandate and doing it professionally, we have been the best, at least under the framework that we have been assessed against. But then that question that you're asking is, so you are best, but who exactly are you? And sometimes people would even confuse us with the Kenya Law Reform Commission,
Yep.
which has a different mandate from ours, which is to propose and look at laws that exist and then propose those laws and even do draft bills for consideration by Parliament to change those laws. For us, we are looking at the laws that have already been provided. But we are going beyond just the laws that are already enacted. We are even tracking the bills, so that you would know there is a possibility that this bill may become law, and therefore I want to have my say, and that essence of public participation in the Constitution comes into play. So you can track the bills through our website before it becomes law, so that by the time it becomes law, at least you are aware of it. You know, it is said that ignorance of the law is not a defense, and therefore you cannot say that I didn't know there existed this law. But how do you then come to know about this law? You track it from the time it is proposed. And that is one of the things that we have been doing. So, yes, we may have to do a bit better in terms of bringing ourselves out to the open so that we are known. But I think on the other side, they say, kizuri chajiuza, kibaya chajitembeza. So, by our work, if you go to the organization, to those public platforms, you will definitely see us.
You know,
we are stalking in there.
You know, the simple citizen of the country, including myself, the law is at best a protagonist in this sense. You interact with the law through the police service. You interact with the law when you have an issue that needs to go to court. So these aren't happy moments.
Yes.
There's something adversarial has taken place. At least that is how, and even the way it's reported and the way we believe it. Now, and yet, you talk about a service that is actually intended and purposed to benefit people.
Yeah.
Now, if they don't know about it, whatever imagery they have, whatever belief they've internalized is what will take center stage.
Yeah.
And will continue to take center stage.
Yes.
Because everything you say, I mean, you hear it and you say, but is this not a wonderful thing? Meaning, even before you go to talk to a lawyer, on your own, if you know how to understand and read, you can have a fairly clear idea of where a matter that you have stands.
It is all legal jargon. The law is written in legalese. Case law is coming from the High Court, Court of Appeal, Supreme Court is written by judges, legalese. I am going to access kenyalaw.org. There are ways in which I can get to understand the basics of those laws. With you this morning on KTN Home, on Spice FM and online is Eric Latif, Ndu Oko, CT Muga. And our guest is Professor Jack Mwimali. He is the CEO and editor of the Kenya National Council for Law Reporting. Now, this is a government entity. This is the one that publishes and puts on all the laws and also judgments from courts of, let me use the terms that he used, courts of higher jurisdiction, from the High Court to the Court of Appeal to the Supreme Court, and they are all published on kenyalaw.org. You go there and you find, let's say, Constitution on kenyalaw.org. Trust it. It has not been edited. That is not somebody who is trying to put in a constitution there that says that the president shall be the deputy to the deputy president. It is a proper law. Prof, you have talked about, you pick the law as it has been gazetted
Yes.
by the government printer and you put it. So you're basically a publisher.
We are publisher.
You pick whatever has come out of Supreme Court. You don't edit. If you notice there's a typo that has come from the Supreme Court, what do? You do nothing. You publish.
Not necessarily. Now, that's where my role as an editor comes in, not just being a CEO. Because as an organization, we also are duty-bound to ensure that the law that we put out there are actually clear and accessible to those people. So in most cases, if we find there are errors, and some of them we call apparent errors that appear in the record. Again, I know, and we will come to that discussion, the use of Latin and all those issues. But we call that a decision, say, that has been made per incuriam, that has been made in error. There is a clear provision of the statute which has been misrepresented by an omission in that judgment. We then get back to the judge to see if that was what was intended, so that they themselves can correct that error and reissue their judgment. So that when we do publish, we publish something that is accurate and correct. So we also play that other role of editing, in the sense that we don't just receive and convey it as is to the public. And that is why you will see most of our laws are actually fairly well written. They're edited.
Do you take it back to the source
Yes,
once
we
you've
do.
edited and say, we found this error
Yes.
and we have edited this, confirm?
Not necessarily we have edited. We write kind of annexure to it and say, did you mean section 28 instead of 27
All
on
right.
this? Or did you mean this instead of that which was submitted to us? And then, of course, that person would look at it and say, yeah, exactly, it wasn't 28, it was 27 that I intended. And then they would do the correction themselves because they have the mandate to do it. And even before they now give us for publication, they have to reissue it because these judgments have to go to the parties. To the parties.
Yeah, to the parties. Okay. What is the danger of not doing this? This process that you've talked about, whereby you may see something that looks like an anomaly, and then you say, all right, this needs to go back to the author. What is the danger of not doing that? Because then it can be assumed. I mean, we're all lawyers here, right? At some point, we get it, what he or she may have been saying, and we can just let it slide. What's the danger of not going through that process?
The minimis.
The danger is now you provide information that is out there that is not accurate. one of the things that we need to do is get accurate information out there. But secondly, also, we bring ourselves under the institutions of administration of justice into disrepute. They will be like, okay, these people do not really know their mandate, or that magistrate or that judge or that tribunal chair is not very competent. And human is to err. I do write a lot. But in many cases, when I go back to what I have written, I find there are things that I ought to have said or put it differently, an is that is misplaced somewhere. And therefore, that needs to be corrected. Of course, for us, if it's a small typo, that when you don't really need to take it back to the author, that when we can make those typographic errors and all that. But if it goes into the substance, we do not do any touching, because then we'll be accused of altering or changing the content of what has been provided to us. And similar things happen with the laws that we submit to that are submitted to us for publication.
Sure.
Sometimes we may notice that there is a mistake or an error. We also write a memorandum that we submit back to the Attorney General's office for consideration, so that if there are changes, it is those who are tasked with the changing of that law that do it. It's not us who do it, but we offer them that expertise and technical service of picking out. And even sometimes we do propose through the Attorney General to the National Council to the National Council for the Commission for
Law Reform Commission.
Law Reform, so that they would consider that as an issue that has arisen. We get two conflicting provisions of law. We pick it out, we point it out to the Attorney General, we point it out to the Kenya Law Reform Commission, so that they can consider changes. Similarly, you may have two decisions of judges that are conflicting that come to us. Ours is to publish, but we also pick out those conflicts and point it out to them, so that they will probably, through their own internal processes, address it. So we also serve that role.
Kind of like the question that Eric was asking earlier, because then again, even as you're reporting or putting out this information, it might make sense to the authors and those who might consume it at that level. But then putting it into morsels that because the communication is not just about what you're doing, but the actual communication of what it is that you have said then is important, because for a lot of folks, it may look like French. Okay, not to me, maybe to CT would look like French, right? So how then would you then break it down for people to really understand what exactly it is that you're saying?
Now, that would be beyond our mandate in the first instance, but we also do give that eye of a layman to the documents that come to us, be they laws, be they decisions or judgments, where we bring out these questions. Because, we want to make it as clear as possible. So as we write back to them a memorandum, it will be like, we have looked at it, and this one still doesn't come out very clearly. So we give them an opportunity to reconsider it before it is now published. In terms of case law, you see, it's just between the judges and us. It doesn't have to be gazetted. So that is a bit more direct. Of course, when it comes to law, even if there is an apparent error or an actual error that is visible on the face of that document, even Parliament itself cannot just go and delete and change.
They have to go through the process.
They have to go through an amendment process.
Remove the word.
Yes.
First.
And put this.
Yes.
Prof,
Yeah.
these things that you publish, you pick piece of legislation for Parliament, an act that has now been gazetted
Yes.
in its entirety, from table of contents going all the way, 70 pages. You pick case law, coming the decision of the court, you publish it all the way. In this country, not in this country, in this world, the generations that are, consuming information now are generations that are seeking information in bite-sized form.
Yes.
Wewe soma, uniambie kwa tweet. So do you have that mandate of, for example, there's a new piece of legislation called the Parliamentary Political Parties Act that has been amended and has now been gazetted, right? Do you have the mandate to basically put it in one paragraph or in just one page and give me the highlights the entire import of this law is this, and the other, and then now if I want details, I can go and read.
Actually, when we receive these laws, they don't have those table of contents and all that. Some of them, we are the ones that do provide it for purposes of making it more accessible. So there are value additions that we give. And in the case of case laws, we actually normally do, the case summaries at the top, the parties, the holdings, because what we receive from the court is just the decision and the judgment.
Okay.
Starting from that stage. So sometimes we distill it for the public. If you go to especially the officially reported cases, there are those that we put in as we have received. It doesn't have those introductory part, holdings and all that. But if you go to the official reports now, the Kenya law reports, you will find it has those elementary. This is the decision concerning this particular matter. These are the co-holdings and all that. And that we provide to the public so that they can know. If you go to look at our laws, especially now the official Kenya laws, you will not just find, you have to look through the whole document to find what you want. You will actually have some tidbits on what you expect in this particular decision. And then you can pick from there whether it is relevant to what you are looking for or that is not relevant. Of course, we are also helped by technology these days so that you can easily go and
navigate easier.
Google or search to determine whether the content of what you have is in the body. But we are also value adding into these publications that we are giving. So sometimes you'll find a case has referred to a statute. You don't have to go and open another link. We create a link for you to that statute which has been cited. Another decision has been cited authoritatively, including foreign decisions. Those that are accessible to us, we will publish and link it to you so that you can go
Prof,
and
I'm asking for, this is the Political Parties Act.
Yes.
Okay?
Yes.
I just want one page.
Yes.
Tell me, this law is about this, and this is what it says. Finish. Now, if I want to, you can be putting the hyperlinks.
Yes.
This law is about political parties. It mentions the register of political. Put a hyperlink that will take me to those sections. But just one page, tell me what this law is about, the main things that this law says, and then at least I get to know this is a law about political parties, about party nominations, about parties receiving money, about parties joining coalitions, about coalitions joining coalitions, all those things.
That is not part of our mandate, especially for laws. And generally, you will find that the laws do provide in either Section 1, a short title, and Section 2, a long title or a definition section, where it will give you the objectives of that act and what they are intended to do and all that. So that is done at the drafting stage so that when they come to us, it already has that part. So if you go and look at the contract laws, Section 1 will already tell you this is an act of parliament to do 1, 2, 3 or 4 things. So we don't have to provide that. But for case law, we do.
Do you have a
give you a
mandate
summary
to then start publishing information just for regular consumption? So let's say that I go to the Twitter handle for Kenya law, and regularly I'll be seeing, there's a law called this, and the other, and this is what it provides. And
yes, we are actually now
publishing.
doing that because we want to publicize to the members of the public. If you go to our social media, we'll tell you new decision on this particular aspect, new decision. Now we are doing that. So we are bringing it out, just giving hints that there's actually a decision. And it's helpful even to professionals because sometimes you may not be aware of all the cases that have been decided. So we pick these important cases that are coming up, BBI decisions and all that. We just give that hint and information. That's not an official work that we are doing. We are just helping people access this information. Yes.
In what circumstances do you think that then people would engage with this information? Who? Looking at members of the general public, who? Law students, professionals, civil society, who would be engaging regularly so that I know in whatever area that I am in, that this is a resource that can actually help me in 1, 2, 3 situations?
Principally, the people that we engage with are the legal professionals.
Okay.
We provide the principal service to the judiciary itself, because even the judges now will be able to access the information about decisions that have been made by other judges if they want to access a law. Now, a judge doesn't have to have a collection of books and go to the library. You access it through the Kenya Law website, and that is an official, citable, authoritative source. The lawyers also use that. Law students and scholars use that. But we are also tending now to move towards the public. Because you see, if you go to your lawyer and he tells you that this is as per provisions of contract law, as a prudent person. Now, I want to distinguish between prudence and a person of trade. You see, you as a lawyer, you are professional.
Yep.
You are held to a higher standard because you ought to know. But you as a member of the public, you're also duty bound to just have knowledge about every. So you don't just go to your lawyer and tell him, I want these things, without having looked at the contract. So we give you the law of contract. By the time he's telling you, no, a contract must have this, at the back of your mind, but I saw in the law of contract at Kenya law that it requires this. So you can still even engage much more effectively with your lawyer, having had an interaction with these provisions. If he tells you the courts have already decided, then you can easily yourself go into those documentations and say, okay, I saw this, but I've also seen that there's a conflicting decision. What about that? Sometimes you can even help your lawyer be a good lawyer to represent you by having an access to this information. And that's what we are doing. Public accessibility of this information for us is important, so that you don't just leave it to the lawyers to do their thing. Sometimes lawyers may be...
They need to be wind assisted.
Yes. But if you know, if your lawyer knows you know this information already,
the likelihood of them to hoodwink you is lower.
It's lower.
Prof, you know, there are very many times when you go into social media and you see information then circulating. For example, just the other day there was information about the traffic laws of Kenya.
Yes.
And whether the cows have right of way and whether you do have right of way. Remember, circulating on social media.
Yes.
Do you have the mandate to do those kind of things? Just distilling the law and sending it out there. Those things that are, of public interest. Traffic laws, laws on loitering and gathering.
Business licensing.
Licensing, marriage, divorce, matrimonial property, such, where you can just put it on a tweet. And if you are getting married, this is what the law says. If you are cohabiting with somebody, I know this whole living for 2 years, that is considered legal. Is it true? Is it not? Maybe you can just come in and start saying, because you're picking these conversations from the public and then putting that correct information out there.
The challenge we'll have with law is it's subject to interpretation. You give two lawyers the same thing, we will argue until the cows come back home or the chicken come home to roost. It is not always straightforward. So sometimes you do not want to engage on something that you may believe is the position, but which another person may find not to be the actual position. So we also like to be neutral, to allow for those debates and arguments, and that develops the law. But having said that, we also do nudge people. We don't give them as authorities, because you'll come and sue me and say, Kenya law published and said this is a position of the Marriage Act, and I did this, and it went down south, and therefore they are responsible because they have given improper legal information. So we don't want to do that. But sometimes we throw out nuggets, tidbits, so that people know, there's this new marriage law that requires these new or which carry these new preconditions. So we just give them a nudge without necessarily authoritatively telling them this is the way it is, to also cushion ourselves against biases.
Let me ask you something. This work that you do, I am hearing a lot of reading, a lot of understanding, a lot of referencing.
Yes.
How many people do you have working with you?
That's the challenge that we currently have. We have 72 members of staff. Those who do the technical work, about 20. Now, technical work is quite immense. There's a Laws of Kenya department, which just deals with receiving the laws, updating. There's another mandate that we have been given. Under law, there's what we call annual supplements. Every time a law is changed, you need to also include those changes and reforms and amendments so that you update that law. And that is required to be done by annual supplement by the Attorney General. That mandate has been given to us by the Attorney General. So we do that. So essentially, we will have so many people dealing with annual supplement, so many people dealing with the laws of Kenya, and that is in the laws of Kenya section. Then there's the other section that is dealing with case laws. And remember, now we have counties. There are also county legislations that we need to report on. So we are really, really constrained in terms of manpower. Actually, our staff establishment shows that we require about 152 people, but currently we have 17. Of course, there is the support staff, 152.
Yes,
and we have 72 currently.
72.
Yes,
less than half.
Yes.
You see, what it then means is that the very same, we've had similar stories with the judiciary.
Yes.
Where when we're told the caseloads that people have on a daily basis and what they have to deal with, we actually had to ask, so what time do you have for your own life? Because, and I'm going to ask the same question of you.
Sometimes you need to dedicate some bit of time to yourself. But having said that, I really have a very good team that I'm working with. They are very committed individuals and people. And that is why I've said it's one of the best organizations to even work at. People who really love this law and love the work that they are doing. Of course, my desire as their boss would be to create an environment that is much more facilitative, understanding how they have gone out of their way to do the things that they are doing. But they are really, really good professional people. And to their credit, most of them who go out of that organization find themselves in very good positions in other entities, both civil society, corporate sectors, because they have learned the ropes. You know, you actually come in touch with these functions. Some of the best legal practitioners in the courts today actually have gone through Kenya law. Some of the best corporate legal minds have come through Kenya law because they have gotten that experience from there. Not just the interaction with the law, but even the work ethics. That's one of those things that probably the current generation need to be pushed or nudged to learn. That it's not always about me going to become a lawyer to make money. Sometimes there's that element of dedication, public service, passion towards what you're doing. And if you get them to do this, you know you'll get better professionals. And I can tell you, you name them, they have passed through our systems.
Prof, you are a professor of law. You've been a dean at the School of Law. So you've taught law.
Yes, I've taught law.
And now you've said the kind of wealth of knowledge and experience that people get when they go through Kenya law. Do you think it would be a good thing to say, let's say at university, one of the things that you will do is intern at Kenya law because you need manpower.
Yes.
And you need sets of eyes.
Yes.
Maybe intern at Kenya law or pupillage should also happen at Kenya law.
Actually, currently we have 17 pupils interning with us.
Why only 17?
Again, you see, the government does have those regulations. Previously, we used to get these interns as and when we need them. But now, because of the centralization in the system, we have to get them from the Public Service Commission. So when we have need, we will have to go through the Kenya Public Service Commission, and then they'll bring it to us. Now, it would not also be fair. You can imagine an intern comes to the organization and you can't facilitate them even with the transport because they are volunteering. So there are financial implications. Of course, there are limitations in budget in our organization. And that's why we have been thinking also of partners. If we can get people who are sponsoring us, then we can easily also bring in these people, give them this experience. We would probably, and some of those functions, you see, if you bring an intern, from Kenya School of Law, from a university, who is out for 3 months. You train them for a month, for a week, and you allow them to work for 2.5 months. They will learn the ropes. Our work will be done, and they have been very helpful because otherwise we would not, with the 72 that we are talking about, and 20 being the lawyers now who do the technical work, we will not be able to manage all that, including the tracking of legislation that are going through the process. We are not just giving you the laws that are already made. We are not just giving you case law. We have to go to the counties, look at what the counties have enacted, bring them all.
Broad.
So we bring these interns, and they do help us.
What message would you like to send out to the public today? People who have maybe interacted with Kenya law, they did not know that was you. People who interact with you, they know who you are. But mostly for the people who do not know about Kenya law.
What I would want to tell the public, part of the right to access information is also a duty of going out there. You know, you can take cows to the river, but you cannot force them to take the water. We will try as much as possible to make it as easy as possible to the members of the public to access this information. But I also want to encourage them. Have time to look at your cases. Don't leave it to the lawyers or the professionals to do it for you. Sometimes look at it yourself. The new constitution, or it's now 10 years in, 12 years in, we used to call it new constitution, does actually provide for a framework for people to be able to understand. So it requires that the information that we provide there are clear, are accessible, are not very technical. You can now go and look at those laws.
And you will find it.
And you will also understand it.
kenyalaw.org. kenyalaw.org. This is the portal that Prof is talking about. Professor Jack Mwimali is the CEO and editor of the Kenya National Council for Law Reporting. We've been having him in the show. Asante sana for joining us.
Thank you so much.
This is Kenya's biggest conversation.